establish and build a comprehensive database in the interests of national security. Clause 17 would make provision for the taking of non-intimate samples from citizens who have been deported both before and after the coming into force of this new Act, and also from non-citizens who have been detained under the Immigration Act. This is another radical change from the current law, which will serve to strengthen our databases and investigative capacity, as this information may prove to be of invaluable assistance in the event that the deported or detained person was convicted of a criminal offence abroad or is wanted for any outstanding criminal matters in this jurisdiction. I now turn to Clause 18, Mr. Speaker. In recent years, our nation experienced an unprecedented surge in the kidnapping of persons for ransom, many of whom remain unaccounted for to this very day. The families of these missing persons, understandably, have had their lives turned upside down, always searching for their loved ones, needing closure. Occasionally, we see and we read reports in the media that unidentified human remains have been found, or that the remnants of clothing and other items which may belong to a missing person are discovered. There is obvious benefit in the use of DNA technology to assist in identifying missing persons, or even the bodies of deceased persons which are in such an advanced state of decomposition that the identity of the individual may only be determined by forensic DNA analysis. This clause seeks to address these issues and would make provision for forensic DNA analysis to be carried out on an item belonging to or used by a missing person on any biological material found on the body of a deceased person or on any item attributable to a crime scene. We are helping to bring closure to all those who have lost loved ones. If for that alone, I expect the support of the parliamentary opposition. Mr. Speaker, one of the most important uses of forensic DNA analysis is in identifying crime and catastrophe victims. A prime example of the immeasurable value of DNA evidence was its use in identifying the victims of the September 11, 2001 attack on the World Trade Center, which presented a unique forensic challenge as the number and identity of the victims were unknown and primarily represented by bone and tissue fragments. Clause 19 deals with persons who have been the victims of sexual offenses. This clause is for those women who have been raped. This clause, clause 19.
Honorable Member, you have 10 more minutes. At 4:05, your 75 minutes will be up.
My
75 minutes will be up.
75?
Yes.
Yes, thank you.
4:05.
Yes. Clause 19 deals with persons who have been the victims of sexual offenses. Where a report of the commission of a sexual offense is made, the police officer taking the report shall without delay make arrangements for the alleged victim to be examined by a qualified person. The consent of the alleged victim is not required for the taking of the sample, and the qualified person may take both intimate and non-intimate samples from the alleged victim. The rationale behind this provision, Mr. Speaker, is not to subject the victims of sexual offenses to undue trauma. We acknowledge and respect the rights of individuals to privacy of the person. However, we proceed on the basis that if an individual having set the wheels of justice in motion has nothing to hide, then they have nothing to fear. Too often, cases involving the alleged commission of sexual offences fail for lack of evidence because the alleged victim refuses to testify through embarrassment or fear. Additionally, the physical evidence may just not be available to the prosecution because of a delay in reporting the alleged sexual offence to the police or the refusal of the alleged victim to submit to the taking of a sample. Mr. Speaker, this provision may appear to be draconian, but this government is about getting serious and making the criminal justice system work efficiently so that the guilty are punished and the innocent vindicated. I repeat, nothing to hide, nothing to fear. Our focus, therefore, is on ensuring that justice is served, both for the victim and for the alleged perpetrators of these heinous crimes. It is also a fact that individuals are often falsely accused of committing sexual offences. The mandatory collection of DNA samples from not only the alleged victim, but also accused persons would certainly reduce the likelihood of cases collapsing before the courts for want of evidence and ensure that the innocent are exonerated. Mr. Speaker, I have explained in the preceding clauses 12 through 19 the circumstances under which and the persons from whom non-intimate or intimate samples can be obtained. The purpose of clause 20 would be to set out the conditions which a qualified person who takes an intimate sample must adhere to. As its name suggests, an intimate sample would be a specimen of biological or other material taken from the most intimate and private parts of a person's body, namely from any part of the genitals or a bodily orifice other than the mouth. It stands to reason that only a qualified person, as defined in the bill, should be allowed to take an intimate sample in accordance with specified guidelines, which would maintain the integrity of the process. Mr. Speaker, it is critically important that the integrity of a sample taken from a person pursuant to the provisions of this bill is maintained. This is the purpose of clause 21, which provides that a police officer or qualified person who takes a sample shall, as soon as practicable, submit the sample to the Forensic Science Center for DNA analysis. Clause 22 provides that a sample shall not be taken from a child or incapable person unless the representative of the child or incapable person is present when the sample is being taken. The representative being defined as parent or legal guardian, person over the age of 18 who has custody, charge or care of the child or incapable person, attorney at law, qualified social worker or representative of the Children's Authority. Clause 23 would provide that a person authorized to take a sample may use reasonable force to take and protect the sample. Part 5 of the bill comprises clauses 24 to 25 and seeks to establish post-collection procedures, Mr. Speaker. Clause 24 sets out the duties of an analyst for the purpose of the Evidence Act. Clause 25 is an important provision which deals with the length of time samples may be retained by the Forensic Science Center. Provision is made for the retention of samples for a minimum period of 10 years, unless a court orders that the sample not be destroyed. Mr. Speaker, despite privacy concerns, this is the benefit of retaining DNA samples. The bill therefore seeks to extend the scope of the existing legislation by providing that within 3 months of the end of each calendar year, the Forensic Science Center shall provide the Commissioner of Police with a list of samples it proposes to destroy. If the Commissioner does not object to the destruction of a sample on the list, the sample may be destroyed. Mr. Speaker, Part 6 of the bill comprises through clauses 26 through 38 and provides for miscellaneous matters which relate to the taking of DNA samples, the storage of DNA profiles, and the sharing of DNA data. Clause 28 would provide immunity from civil or criminal proceedings for persons involved in the taking of non-intimate and intimate samples, except where there was a negligent act or omission on the part of the person in the taking of the samples. Clause 29 sets out the circumstances under which the custodian or a person authorized by him may disclose DNA data. Where DNA data is disclosed outside the specified categories of persons, the person making the unauthorized disclosure, Mr. Speaker, commits an offense and is liable on summary conviction to a fine of $100,000 and imprisonment for 7 years. Clause 30 would set out the offences which can be committed by a person under the proposed legislation. Clause 31 would provide that a person who refuses to give a sample or otherwise obstructs or resists a police officer or qualified person in the exercise of his function under this Act commits an offence and is liable on summary conviction to a fine of $10,000 and to imprisonment for 2 years. Clause 33 would provide for the admissibility of documentary evidence in criminal proceedings. And Clause 34 would empower the Minister to make regulations for the purpose of giving effect to the Act. Clause 36 is a validation clause, Mr. Speaker, which would provide for the acts of validation of things done under the Act. Clause 37 would provide for the repeal of the Act. And Clause 38, very important, would be a savings provision, which would extend to any action taken or any samples or DNA profiles obtained under the repealed Act, prior to the coming into force of this new Act. Mr. Speaker, the government is firm in its resolve that the introduction of this bill is timely and necessary as we continue our efforts to stamp out the unbridled criminal activity which now plagues our nation. Members of this Honourable House, the spiralling levels of crime and criminality that face us demand that we bring all our systems and processes and the legislation that govern them into the 21st century. What we face now is the proverbial bend in the road, the signal moment in our history when our nation, our fellow citizens, are depending on us, their representatives in this Honourable House, on both sides, to take the bold and decisive steps that will send a strong message to the criminal element in this country. I accordingly appeal to the honourable members on the other side to put partisanship aside and put country first. Let our children and grandchildren remember this moment as one of the many in our history when the vote was mightier than the sword. These proposed amendments, honourable members, together with the other legislative measures the government will soon introduce in order to strengthen and enhance the criminal justice system, will not be a panacea for all the ills we currently battle. We recognize that one piece of legislation cannot be used like the proverbial magic bullet to correct all the problems of an ailing society. But we are making incremental steps. We seek justice in the courts and an end to miscarriage of justice. This government is committed to reducing and preventing crime and tackling the fear of crime. We are also committed to supporting our police officers who are the foot soldiers in this battle against crime.
Just take a minute and wrap up. You pass the time.
Yes. Mr. Speaker, every day real crimes affect real people. The impact of crime on victims, their families, and on the fabric of society should never be underestimated. Without a doubt, DNA profiling will foster a level of public protection, enhance public confidence in the criminal justice system, serve to bring the guilty to justice, and most importantly, it will ensure that the innocent go free. This will undoubtedly be of inestimable value to the lives of our citizens and the future of our beloved nation. Mr. Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled an act to repeal and replace the deoxyribonucleic acid DNA Act, Chapter 534, be now read a second time. Honorable Member for Diego Martin Northeast.